Let me introduce my guests for this morning on this very edition, which I think should mark the end of one particular subject we have discussed for almost a decade. My guest, Abdul Malik Wekubaku, Editor-in-Chief of the New Crusading Guide newspaper. Inus Afuseni is the MP, Tamale Central. We'll be joined shortly by Randy Abe, his host, Good Morning Ghana, on Metropolitan Television. And here, also very excited to receive, is Dr. Peter Atopare, Senior Lecturer, School of Law, University of Ghana, and partner, Colendi at Law. Gentlemen, good morning and welcome to Newsfile.
Thank you.
Great. Okay, so let's first begin by listening to Alfred Agbesi Woyome and also Godfred Dame Yeboah, the Deputy Attorney General, who in April 2017, soon after this government was sworn in, embarked on a continuation of a crusade. And people say this time with more commitment and sincerity to retrieve 51 million Ghana cedis allegedly paid to a man under mistake. Let's hear them.
Then did all that they can do without a court order, that they were taking valuations. I can hear them talking about some values.
20 million is currently.
Which is, where did they get that figure from?
Of course, but if they are broken into your house to do valuations.
What valuation? They come and measure the land and everything. Valuation is different. There must be an independent valuer. You are the judgment creditor. Did the court appoint an independent valuer?
Did the court appoint one?
No. I don't know of one. I don't know of one. So if now they want to talk about a value, they must go back to the court or to appoint an independent valuer, and we all will have to agree on the value before they start throwing out figures.
Is it that you are disputing the amount to be more
excuse me,
than the actual amount?
Because there could be corruption there.
I don't get you.
You don't get me. I'm disputing that amount because it is not true what they are stating.
Is it way higher or lower than the amount?
Far, far lower.
Far lower.
Look, law of the Constitution. If I win and the Ghana government do that, then I can call it there is a coup d'etat of the Constitution. That's what I'll call it. And I am boldly saying that. Because that is the fact of it. So it's going to be trampled upon. Then let's see what it is. The issue here is that let's wait for the Arusha. If government win, I'm ready to sit with government and schedule this. This thing, I'm going to sell this, it's cost this, it's cost. I've never told the government Alfred Woyome is not willing to pay.
Or cannot pay.
Or cannot pay. The issue is there. Or can Indiana?
Of course, there's always a settlement plan. That's
exactly. Exactly. Then life begins. Then I know that I believe that I am doing a right thing by defending the right of myself, the Constitution, and the Ghanaian. And if it ends somewhere, we've all learned lessons. It's legal lessons. You understand me? We will sit down, and then I will bring a payment plan. And
he's always been making these outrageous claims, and I wonder why he does so. He knew that it was court bailiffs who were the registrar of the Supreme Court in exercise of his powers after there had been an attachment. There was filing of what we call a 5A. He filed a 5A indicating that his properties that were placed under attachment. And then the court appointed bailiffs and officers proceeded in the company of policemen and security officers. And that is what happens in every single case. We do not go into onto a person's property trying to value it without protection. Definitely the bailiffs and officers of the court that to have protection, and they have protection from police, and that is lawful. And after that, they were properly valued, and we're proceeding to the next step of applying for the properties to be sold pursuant to the termination of reserve price when these outrageous claims were made by UT Bank and all. So he made such contentions before the Supreme Court, and they were dismissed. So he has no case at all.
So how do you intend to recover the remaining sum?
Yes, so what we intend to do is what I intimated yesterday. Yes, the rules of court enjoin us to file or require application for determination of reserve price. We're not going to circumvent any rule in all of this. We're going to ensure that we act in strict adherence to the rule of law. So we're going to apply for the determination of reserve price. That is the price at which the court will sanction the sale of the properties, and the price will be the full sale value. So indeed, he ought to know that it is not the market value that is used in these circumstances. The court will always determine the price based on the full sale value, because it is a full sale. It is not a sale that is voluntarily being made by a person. Like, for instance, if you have a property and want to sell, you're going to sell it in accordance with what you will consider to be the market value. Yes, it takes your time to do so. But in this case, there's a price of time, there's a need for us to sell it quickly, and therefore we're going to apply the full sale value. And we'll do that.
On merits, unanimously finds that the respondent state has not violated Article 2 of the Charter on the right to non-discrimination, finds that the respondent state has not violated Article 3 of the Charter on equality before the law and equal protection of the law, finds that the respondent state has not violated Article 7, subparagraph 1A of the Charter on the right to have one's cause heard by a competent tribunal, and finds that the respondent state has not violated Article 7, subparagraph 1A of the Charter on the right to be tried by an impartial tribunal in respect to the composition of the review bench of the Supreme Court. By a majority of 7, 4, and 2 against, Judges Gerard Nyungeko and Rafa Ben Ashur, dissenting, finds that the respondent state has not violated Article 7, subparagraph 1D of the Charter in respect to the remarks made by Justice Dodson in his concurring opinion in the ordinary bench of the Supreme Court. On reparations, by a majority of 7, 4, and 2 against, Judges Gerard Nyungeko and Rafa Ben Ashur, dissenting, rejects the reliefs sought by the applicant. On costs, unanimously decides that each party shall bear its own costs. The judgment has been signed by the judges mentioned at the beginning.
Right. Good morning, Randy.
Good morning.
Great. Okay, so I start with Abdul Malik Kubako, editor-in-chief of the New Crusading Guide newspaper. So in July of 2004, the country wins the bid to host the Cannes 2008. Then we begin to advertise, and we ask for tenders in 2005 of January. Then there are bids, and there's some process through which Woyome and his companies get involved, and eventually we're told, bottom line, monies were paid, and then when the new government came into being, he wrote asking for same money to be paid, and somehow the money was paid to him, somehow like twice, if that's a better summary of it. And we have been chasing that money ever since.
Well, not a bad summary, but I think there's a loophole somewhere.
Mm.
Mr. Woyome himself is on record to have said that he had no contract with the state or the government of Ghana relative to this whole transaction. That's his own statement that he placed on public record, I think with an interview with Kwame Sefakai on Kokoko. So really, whilst your summary is okay, I'm not sure what will be by Mr. Woyome and his companies. But I think perhaps what you meant was that he was affiliated to certain companies that were involved formally and officially in that transaction. In this case, we may be talking of Waterville and to some extent Austro Invest, you know, and if you like Empower Park, which really he wasn't the owner, was one Ray Smith who was connected to the Austro Invest entity, you know. So Mr. Woyome had no business writing to a successive government demanding some monies that were due him, allegedly owed him. He had no business doing that. And indeed, it is those who were in charge of the successive administration who are really the problem, as far as I'm concerned. And I can see my brother shaking his head. But these are recorded. Even the Supreme Court, in passing its judgment, actually took a shot, not just about the lawyers, but the Attorney General of the day and others. Yeah. And if you read the records, you will see that things that were processed in defense of Mr. Woyome against the advice of the Counsel for Waterville, Mr. Tete, you will see that but for those who were part of the administration, and Woyome's own testimony at the High Court, he talks about a committee that was formed at the castle, and it was headed by a good friend of mine, Mr. Alex Sebefia, who was on this program some time ago defending Woyome and insisting that Woyome had a case and that he ought to have been paid those monies. On this very show, you remember Barton Odro telling the whole world that Woyome had a case.
Deputy Attorney General then.
Then, who subsequently became Deputy Speaker of Parliament. Then, of course, Madame Betty Mould herself, based on her conduct. So there's enough evidence to show, to vindicate the point I was making, which my brother was shaking his head to, that functionaries, and I'm not talking of the administration in its entirety, I'm talking of functionaries, people who had been given positions of responsibility to ensure that public resources were used and used for what they were required for, failed in discharging their duties. It's as simple as that. Mr. Woyome's connection to this Power Park agreement between Waterville, he was paid for. I'm glad Randy Abe is here because he led the charge in the exposure. He was paid for, and he acknowledged it, signed. So, relative to that whole transaction or the rehabilitation of stadiums or construction, his case was finished. He took advantage of the fact that the previous government had existed and put in that thing. And the new authorities, those who were in charge, did not do due diligence to double check that what he was saying was true. Indeed, at one stage, a deputy information minister told the whole world that the documents were missing. The documents, the file on Woyome were missing. So that's what it is. There's no need. I'm surprised. Mr. Woyome has some, is it courage? Is it misplaced aggression? I don't know. But he's a very interesting personality.
He's been able to sustain suits since 2009.
I will grant him that. So but it's a misplaced aggression against nobody. Self-inflicted challenge on himself. Look, we said it here, that he can run, but there will be no place for him to hide. You remember when he was going to ICC and the African Human Rights Court? We said it here on this very table, that a man can run, but there will be no place for him to hide. For me, what has happened is good enough. And I salute Martin Amidu with all his challenges, with all his imperfections, with all his limitations. The truth of the matter is that it was the Auditor General of this country that had indicated that unlawful, or if you like, payment, if I may put it so, because of the Supreme Court decision, I can comfortably say unlawful. And then Mr. Japon pointed to that disclosure that had already been made in the Auditor General's report and left it there. It's the media, led by people like Randy Abe, who went now for the documents and did a huge case out of the matter. Subsequently, it would all have meant that but for Martin going to the court. And he went through the process seriously. So he stands out. Of course, based on the Supreme Court's ruling or judgment, issues began to happen. The question of attaching his properties and all, and admittedly, it began January 2015. But new processes had to be filed by Godfred Odami to galvanize the process for us to reach this stage. Because of course, Mr. Woyome kept fighting. You pass here, he passes there. He passes here, he goes there. So there was a battle, and it needed a certain commitment and determination to ensure that we would reach where we have reached. I'm not even sure that we are going to be able to retrieve the money in its entirety. I'm not even sure about that. But at least it's better than none at all. My final take on this, and I've been saying it, and fortunately for me, Martin agreed with me, that there's what I call a missing link. I don't know, you are the lawyers, I'm not a lawyer, so I don't know even if it makes sense to make this proposition I'm going to make. But those who collaborated with him, you remember when the case went to court originally, there was a nollie prosequi that was filed. And when it was filed, Mr. Woyome was the only one rearrested and charged. People like Asimeni, the Director of Finance, then at the Ministry of Finance, or is it Liga, Director of Liga, at Ministry of Finance, Nikwe Tete,
yes,
and 2 or 3 others were left off the hook.
Nikwe, whose account or wife's account
was a beneficiary.
400,000 was traced to as payment from Woyome.
Yes, and then of course the politicals, quote unquote, the Betty Moles, the Barton Drews, ought to have questions to answer. It's as simple as that. We should interrogate that missing link. Look, Yoko did a report, an interim one. They never finalized. They didn't give us a final report. All those things enabled Woyome to up his misplaced aggression, thinking that the state was either impotent or incapable or both in handling him. So to be honest with you, my view is that we haven't finished. We finished maybe chasing the man who really took the cash, but he didn't walk to the bank, as he's been saying, with a gun
Godfred,
on top of some.
That because of what the Supreme Court has just recently found, where when his properties were being sought to be attached, there was a claim by UT Bank that the properties had become theirs. And now eventually the court found, in Justice Benning's decision, found that there was a collusion to try to conceal the ownership of the property, that in fact they belonged to Woyome and did not belong to UT Bank, because they had allegedly done a sale agreement transferring the property to UT Bank. Nonetheless, sometime after that sale had been done, Woyome still manages to use the same property to secure a loan.
Yeah.
A property belonging to UT Bank has been used as a collateral by the person who long ago has sold it to secure a loan.
Yes.
So Godfred is saying on that basis, they still are able to proceed to court to file, as it were, criminal charges.
Yes, you are the lawyers. The conduct of the banks and all those involved in that, you can define it. And tell me whether any provision in our statutes could capture that, make them liable for prosecution. You may have to educate me on that, but in my commonsensical way, I think there's something fishy out there. Final point, I heard Mr. Woyome say Kafu Didi. Did he say that?
Yes.
But Kafu Ndi Abenkwai. This, I recall, happened in the Busia era. Kafu Didi, but Kafu Ndi Abenkwai.
Okay, so you hold on there briefly, and let me bring in Randy, because you referred to him many, many times. So remember how this whole thing began, and you know, the floodlight that you threw on it. And then Joy FM also went to the court, procured the court documents to bring sunshine to the fact that the state itself, after Woyome filed his suit, the state just went to sleep. He amended his suit twice. Then he got default judgment. We didn't seem to be bothered. He got default judgment. We went and met him and begged him and said, look, we'll pay you, let's settle. We write to the court to tell the court that, look, he's entitled, pay him. Then once he's getting ready to be paid, we file another process. And the court says, if you, the one says we should pay him, you still come with reservations long after you have already allowed us to grant him what he needs, then pay him only 17 million of the 51. Don't pay the rest. Let him sign an undertaking, and that when the matter ends, and he's not victorious, he'll refund the 17 million. On the blind side of, as we have been told, the finance minister, the president at the time, President Mills, on the blind side of the court, we paid him all the money.
Something. I don't know if I should say that it's exciting news or not. But you see, this whole thing shouldn't have happened. It should not have happened
at all
in the first place. It shouldn't have happened. And it obviously happened because state actors either colluded or slept on the job and allowed Mr. Woyome the opportunity to put together his craft and benefit from same.
He keeps the refrain that he never put a gun to anybody's head.
That's why I say, I make the point that either state actors colluded, slept on the job, or did both. You know, because yes, it's true. He made claims. He went to court. The state was aware of his actions in court. They did nothing about it. The court went ahead to do its job. Then the state woke up and decided to act on it. You know, and Kweku referred to, I mean, a lot of correspondence. For some time, I've decided to, you know, just put all my documents somewhere. But if you read a lot of the documents, the communication, AG's office, Ministry of Finance, and others, and you read what people working for the state, I mean, their opinions and positions on the matter, and then their public pronouncements on the matter, I mean, it's pretty obvious that either people were incompetent or they were in collusion with Mr. Woyome. And I make this point because, you see, as we speak today, we have the benefit of the hindsight of court decisions. Mm-hmm. You know, so it is not about you speculating. The courts have pronounced on the matter after the Auditor General made that disclosure that, look, the payment was wrongful. The courts have since been asked to pronounce on the matter, and they've done so. And by conduct, the state itself, the previous government, by its own conduct, agreed with the position that, look, the payments were wrongful, and proceeded to want to retrieve those monies. Mr. Woyome himself, by conduct, has agreed that, in fact, the payments made to him were undeserving. And by conduct has proceeded to take steps to refund same.
He paid 4 million.
If for nothing at all, in November of 2016, he paid 4 million. And that was based on a payment plan. I'm surprised he's still talking about a payment plan.
He now explains why he made the 4 million payments.
And he says?
He said the Supreme Court at the time had ordered him to pay. He could not be seen or heard or found to disobey a decision of the Supreme Court. That's why he proceeded to make that initial payment. But after that, he took steps, and therefore the payment was halted.
The Supreme Court ordered him to pay, but the Supreme Court didn't put out a payment plan.
That's right.
The payment plan, which then led to the initial payment of the 4 million, was an agreement between him and the then Attorney General's Department of the previous government. And they then agreed on the payment plan. So it is true that the Supreme Court ordered him to pay, but the Supreme Court did not provide a payment plan. So his position cannot be totally correct.
That's right.
Because in furtherance to the decision of the Supreme Court, he sat with the AG's department, same opportunity he's asking for today, and then agreed that, okay, Supreme Court says I should pay, I agree, but let's have a payment plan. So maybe I'll make quarterly payments. To show good faith, this is my first payment of 4 million. He defaulted when the second payment was occasioned. And that is what then led Godfred and the current Attorney General to then decide to go attach his properties, because they felt that he was not going to comply with his own payment plan. So I'm saying that if you look at later events, after all the crusade and all the talk that we've done, the pronouncements of the court and everything, and the conduct of the then AG's office and the current AG's office and Mr. Woyome himself, the issue of wrongful payment is beyond doubt. That is beyond doubt. And what the state has succeeded in doing now is to say that, well, if you will not voluntarily go by a payment plan, we will try and use the law to get what we can get in terms of your assets. So that's what they've done. They put it at 20 million, but you know, Godfred hinted of for sale value. So we pretty much will be looking at figures lower than the 20 million. Because if you've been involved in auctions and all that, you would appreciate that the market value and for sale values are not the same. Normally, most of the time, for sale values are lower or lesser than the market value.
But he explains also that the figure 20 million put out there by the media is inaccurate because they have discovered other properties. So in his estimation, you should be looking at about 10 million extra to the 20. Woyome also is claiming now that if the properties are properly independently valued, he alleges they are not independently valued. If they are independently valued, you will be looking at far in excess of the amounts that are being mentioned.
Well, something, we don't need to create another controversy over this. These are very simple matters. One, the Attorney General claims that they sent valuers there with police protection to go and value the properties.
Right.
The owner of the properties say that he disputes those values. It can be resolved.
Yeah.
Easily, it can be resolved. It's by calling upon the court to appoint independent valuers to go and value the property. This is not an issue that anybody should, speak about. The 20 million is a figure put out by the Attorney General that they send valuers. This is the value the valuers have put on the properties. If he, the owner of the properties, disputes it, there is a legal way. The court will deal with this issue simply. It's not an issue at all. Now, if the Attorney General also claims that they have identified other properties, as we speak today, those properties are not an issue. We do not know those properties. They have not made a legal claim for them. We do not know the response of Mr. Woyome or those who perhaps are affiliated to or associated with those properties. So I prefer to speak to what is an issue today, to what has gone to court, to what the court has pronounced on, and the issues that Mr. Woyome raises. So if his contention is that, look, the valuation I disagree with, he makes a case at the court. In any case, the Attorney General is now going to start a process of going to the court for the court to order the for sale value and all that. Right. It's an opportunity for Mr. Woyome to go dispute the issues and say that, look, I disagree with the valuation. The court will call on an independent valuer and it will be done. Yes. And that will be sorted out.
You're right, and that's quite basic. Yeah. Yes, your regime has been accused, and there is evidence to back the accusation.
Yes.
Now, what was going on in the name of attempting to recover the money paid under mistake was just a small screen. You were not committed, because the evidence will show that from the point of payment, including at the time where Waterville's lawyers, Tete and Co., wrote to the government indicating that the man has been paid, don't pay him a second time, you knew that you didn't have to pay. You went ahead, you paid. Then he did everything, got that default judgment, then you went to court. Subsequently, a judge says, pay him only 17, don't pay the rest. You went ahead, paid him all that money on the blind side of the court. So the steps taken to recover actually were first initiated by Martin Amidu himself, not the Attorney General. And subsequently, when he sought to cross-examine Woyome about his assets, the Attorney General actually filed the process opposing that Martin Amidu should be allowed to do that kind of job.
Right.
So the evidence is there to support the claim that all that you were doing was not sincere.
Oh, thank you so very much. But before I even contribute to this debate on the floor, let me acknowledge the presence of my lecturer, distinguished Mario of the Euro traditional area.
Right.
Justice Atupari. I was privileged to have sat in his class when he taught me natural resource law, and also to.
He taught me too. He taught me too.
Well, I mean, and you can't fail to be excited when you are listening to him teach in a lecture theater. I wish I were. I had gone back so many years to be with him.
So my difficulty this morning when I got to know he was on the show included, more importantly, how to introduce him, the chief.
Yes, the chief. Yes.
I meet him in court as a lawyer.
Yes, and to say good morning to my distinguished friend, Kukubako, and my brother, Randy. And when Randy was talking about falsity, I knew where he was coming from. But to say that, I mean, when you look at the facts, you might not be entirely right if you say that the NDC government did not exhibit the level of seriousness in retrieving the money. You might not be entirely right, because there is evidence pointing conclusively to challenges to this payment by the then finance minister, Dr. Kobna Dufo.
Right.
There's that evidence. There's that evidence that shows that when the baton changed from Betty Moldedrus, the new AG took steps to reverse the process, filed several processes in court to set aside even the consent judgment that was entered into between the parties. So there's that evidence. Yes, on a personal note, I have never believed in the rationality and legality of the payment. I mean, if you look at the facts, like my brother Kukubaku said, you fail to see the nexus between government and Woyome and the foundation of the claim. You fail to say it. And then if you even trace the history of the in quotes, financial arrangement that was entered into between Woyome's company, he said that's his company, Power Pack, and Waterville. And the fact that Waterville was initially given the permission to start construction prior to the signing of the contract, and then stopped midway, and then the work there they had done quantified and paid. Woyome claims through their lawyer Tete & Co. that Woyome was paid for services rendered.
But just a small matter, I wanted you to wait to finish so I may forget. You said after Betty Moldedrisu, there was a process to set aside what the default judgment he had won or the consent judgment that he got. In fact, it was Betty Moldedrisu who filed that. She filed that, and then that was in 2010, July 28, 2010.
Yeah.
So Martin Amidu comes in, I think 9 months later.
To continue with the process.
Right.
Yeah, so I mean, that is a further demonstration of the fact that, yes, even though the payments were done, at a point during the process, there was an attempt to reverse the payment. And so one cannot say that the actors then did not take steps to remediate or in any case right a wrong, the perceived wrong that they had done. Now this case evokes a lot of emotions in people, and when commenting on it, you will by all means touch on the reputations and integrity of persons who were in office when those payments were made. I have heard Randy use very strong words like collusion and negligence or recklessness in the form of sleeping on the job. And
the court made the observation, not any far from Randy. Randy's may not even be harsh.
Well,
said it was as if an enterprise, a brigade, had been set up to create loot and
that's
share.
Justice Duce. I will not comment on him because, for obvious reasons. And he says, look, those who were involved ought to be brought in for us to understand what went into arriving at the decision to pay Woyome. That might be legitimate or otherwise. But we're coming to the end of this matter. I mean, you cannot take monies from government with a lawful cause and hope to keep the monies. Now, and Ghana has progressed far after these particular incidents. We have passed so many laws that clearly people who might be tempted to take public resources and thinking that they can do so with impunity might have to rethink. Yes, Woyome says that, and he's exhausted almost all the remedies available to you. I don't know whether you want to go to the international court, but
almost all he has.
Almost all.
Almost all, or really all.
Well, we don't know what he's thinking, what is up his lips. But
his last hope was on the Arusha court.
Arusha court.
Yes.
And even that one, he went on the basis of
human rights.
Human rights. Okay, so not challenging the payment that was done to him, but alleging that he had been discriminated against,
including the statements that Justice Doche had made.
Okay, so and the court did not fine for him. Now, so probably Woyome, and I've read him. He's saying that he's prepared to pay. In fact, he categorically said that after the Arusha case, if he lost, he will pay. And so I think that Woyome should be preparing himself to enter into some arrangement or compromise with states to see how he pays the debt. His properties have been taken in satisfaction of the judgment debt. And he alleges that the valuations placed on them do not reflect the true and accurate values that should be placed on them.
You refer to the criminal processes that, you know, Kuku suggested may be very necessary because there ought to be punishment, really. Do you expect that to happen?
Well, I have referred to them for us to understand, to bring a closure to this matter. Not because I think there was some plausible culpability on the part of those who were in office during that time. I refer to them because sitting where I sat in July 2010, or at the time the payments were made, and reading all the documents, I remember walking into the office of Segefia, at that time Deputy Chief of Staff, and asking him why those payments were made, because I simply did not understand why those payments were made. Now, it is important for us to understand what agitated their minds to come to that decision. And that's why I think that a closure in terms of understanding the processes that informed even entering into consent judgment or an arrangement for payment to Woyome and his company probably would be appreciated. And that's why I will support that. Probably we need to understand how that happened.
Okay.
And then see whether we can learn from the acts or defaults of those who were in office during that time. But Woyome is still within his right to claim that the values placed on the property.
Okay. Right. Now, Doc,
the properties are undervalued, and that if he decides,
let's
if
hear,
he challenges that,
Dr. Tupari. Now, see, in May 28, 2010, Betty Moldedrusu wrote to Kwabena Adofo, the finance minister. Actually, she had been asking and suggesting to the finance minister that the money was genuine and it ought to be paid. May 24, 2010, he had already obtained the default judgments. And just about 4 days later, I'm talking about here. What he actually got was for 105 million, not 51 million. The 51 million was his compromise because the government sought to settle. And he said, I will take 51 in full satisfaction of the 105. So eventually the monies are paid. Dr. Dufo says he's unaware. In fact, when Betty writes to him, he ignores Betty's instructions to make the payments. But eventually the monies are paid. If you sit down with Betty today, Betty Moe today, she will tell you she also did not know how the monies were paid. When we are looking at criminality, what exactly is plausible? When the people who were at the forefront, almost all of them will deny that they knew how the man got paid.
Thank you very much, Samson, and thanks very much for the kind words that you expressed about me, and so to Honorable for the kind words you have expressed as a lecturer. I know I am not here as a lecturer. I'm here to discuss issues of national importance, and you have been here before. You're a veteran, so I'm sure I'm going to sit at your feet today to learn. And in respect of this Woyome issue, I would say that we are almost at the tail end of a viable opportunity for the various actors to resolve the matter. Viable opportunity in the sense that there's a court order that the amount of money be retrieved. Now, in the case of Woyome, one fundamental thing for me is that the various actors, in this case, Woyome has a person, and then the state acting through the government, has realized that we have a distinction between a duty bearer and then a right holder. Woyome must have acknowledged, and of course throughout the process has agreed that he's a right holder in respect of these monies. The state has agreed that I am a duty bearer in respect of this right that you hold, and then you are in court to vindicate that right. So in that sense, we must celebrate both of them, that we have not gone back to days where the state thinks that we have the state's the security apparatus at our disposal and has an individual who can bulldoze our weight and then get what we want. They're going through the court process right from the High Court all the way to the Supreme Court. The state has not done anything untoward. The state has not actually demonstrated that kind of naked power, that I have it, and you as an individual, I can really dethrone you, I can engage in any act of violence or aggression and get whatever I'm looking for. It's the due process that is important for the state. It's the due process to acknowledge that we are really matured as a state. We have agreed to the principles of rule of law. We have agreed to the principles of due process, and that is what we need to get. At the Supreme Court, which is the highest court of our land, we've been told that this is a case where, as Randy has indicated, even if the state was sleeping, it was not a permanent sleep. In any case, it wasn't an irredeemable slumber that the state cannot wake up and deal with its responsibilities as a state, and then deal with its responsibilities towards an individual who has rights, and these rights are found in our laws, most especially in our Constitution and what have you. So the highest court of our land said that we have looked at the matter carefully, and where we got to, we think that this is an opportunity for the state to retrieve by issuing an order. And this is what I talked about, a viable opportunity at the tail end of the process for us to know that we're no longer dealing with the substantive rights, we're not dealing with the processes of retrieving the money, in which case you have lost the rights in the monies that you are seeking to collect. And that is very important for us.
The history will record that the Attorney General's department that had, the duty to monitor and follow this through had gone to sleep and abandoned the process. It took Martin Amidu, who was there before, after he had been sort of dismissed, quote unquote, to come out to take a suit on his individual, basis to get the Supreme Court to eventually, on the 14th of June 2013, pronounce that these monies ought to be paid back.
So I mean, that's a praiseworthy act from Martin Amidu, and it's unfortunate that the state institutions have not activated themselves enough to be able to deal with these processes. In order not to bring in Martin Amidu to facilitate the process, which the state is not going to be the beneficiary, the principal beneficiary in respect of these monies that we're talking about. So Martin Amidu's conduct must be praised. It's part of an individual bravery in dealing with the enforcement of the laws of the country, and that he has been part of the club that insists that due process, law, or legality must be established, must be followed in this country. But the most important thing I want to make is in respect of his appearance at the international level, that we should distinguish between a subjective belief that I have a case as a client, and then an objective belief which encompasses an interplay of law and facts. That before you hit court, you may believe that this is what I'm going to get, but that your belief must be objective enough, and for it to be objective enough, it must actually relate to the interplay between law and facts. So at the African court, for instance, there was this belief of Woyome that there's some discrimination. He has a right to be tried by an impartial tribunal, and in that case, there's this allegation that the courts of our land are not impartial enough. And then there's this right he claimed at that level that he has a right to be tried by a competent tribunal. I'm quite satisfied that throughout these processes, from the High Court to the Supreme Court of our land, which is the highest court of our land, to the African Human Rights Tribunal, where he did not get the judgment, the belief has to be that it has to be an objective belief, and that's the court held that there's no violation of his right to be tried by an impartial court. And for me, it's a kind of confidence in our judicial system. It's a kind of confidence in our courts. It's a kind of confidence which we have.
That's a majority decision.
The majority, of course.
There were two who agreed with him.
The majority decision is the decision of the court.
Yes.
So we will refer to the majority decision as the decision of the court, not the minority. I'm not sure anybody can ever refer to the minority decision as the judgment of the court. So in this case, we celebrate both of them. We thank him for helping us build the law, but traveling all the way to the African court, and we thank him for traveling all the way.
So it's end of the game for him, end of the road for him.
For me, that is it. That is it. And this is something that we really have to learn as a state, and then and get to the bottom of the matter and resolve the issue. In resolving, especially in retrieving the money, I agree with Abe that we should still maintain respect to human rights. Maintain human rights in the sense that the valuation process of a property by a judgment creditor cannot be the unilateral act of the judgment creditor. It cannot be. So if Woyome believes that this was a unilateral act of the judgment creditor, Woyome has a right to contest it. And by contesting it means that there is a right also. Because if I have to pay 2 cedis and you value my property as two pesewas, it means I've missed the opportunity to increase the cap. And in that case, by contesting it, he might have an opportunity to deal with it.
Right.
So the state should be careful in that context by looking at it in that way, that it has been consistent to maintain substantive law and due process. And at this level, we should not be faulted as a state.
And like Haruna and also Inusa and Randy have sought to educate the people, this door is not close to him, right?
Sure, I agree. It's not close.
Right.
So far as retrieving the money and at the valuation process is concerned, or the execution process is concerned, it's not closed.
At what point will he come in and say, I need the values looked at again?
Of course, they are talking about going to court to deal with the processes of forced sale and things like that. Of course, you can get to the court to deal with it and say that, look, even whatever we are dealing with is not accurate. It's something.
And what are the prospects of any criminal processes to conclusively deal with the matter? This is for the recovery of the money that went to him. But, you know, fingers have been pointed at various other actors in paying the money in the first place, and now in this final process, in the court discovering and establishing as a matter of fact that there was some collusion between him and the UT Bank.
For me, whether somebody is criminally culpable or not is for the state to decide. In this case, it's for the Attorney General exercising his powers under Article 88, or any person exercising a delegated prosecutorial power to determine. And the facts are with them. So they should be able to examine the facts and see whether any act is criminal, or any act could be taken and in the court, leading to conviction and things like that. Remember, it will go through a trial process, and you must satisfy the elements of the crime you are charging. So you should be thinking about the facts. They should be thinking about any crime and deal with it. Or maybe they think that the retrieval of the money is very important, and once we have retrieved it, we should just abandon the issue of collusion or sleeping and what have you, and go as a state has a healing process. That is up to the state to decide. So I will not risk any opinion to the fact that somebody is criminally culpable in respect of any conduct pertaining to Wyome's case or not.
Okay, but at least we know some of the facts. Can't you pronounce by your understanding of the law conclusively that there's a criminal case to answer? The court found that by the 5th of April 2013 and 5th of May 2013, they executed a sale agreement and then gave title, you know, in the UT Bank for the Trasaco properties, 2 of them, into the bank, which belonged to Woyome, or he and his company, so to speak. And then in September and November 2013, okay, 2013, that's after the sale of these properties to UT Bank, Woyome's company seeks a loan from UT Bank, and the collateral use is the same property. Is that possible? I sell something to you, I come to you later, I need a loan, and I can use that property I had already sold to you to be the collateral.
Shami, however irregular this might seem to us, as you indicated, is a court finding. And when the court establishes these findings, the audience, there's a direct communication to somebody. There's a direct communication to a party, to a state, that this is what we have found as the court of the state. So whose responsibility is it to look at the findings and be able to determine whether there's a crime or there's not? We can speculate, or I can say that in my view it is this. But as you know, Article 88 gives the power to the Attorney General to look at these matters, to look into these matters and see whether there's a viability, there's an option based on the court findings to say whether you are criminally culpable or you're not criminally culpable.
Educate those who are asking the question, if the Supreme Court made this finding, why did it not go ahead to pronounce him criminally guilty and the company, the people involved, criminally guilty and put them in jail?
Because that was not the subject matter. That was not the subject matter before the court. This was a civil case. This wasn't a criminal case.
Okay.
So that is why even in some instances you may have a belief that this person walking the streets of Accra is a criminal. That's your suspicion, that's your belief. It is up to the AG to exercise that discretion based on evidence, based on the docket, based on findings, to say that, look, I am going to prosecute you.
Okay.
And you know that prosecutorial discretion is actually for the AG. And if AG elects to say that I am not going to prosecute based on A, B, and C, the AG's discretion being exercised in that context may not be contested. Is it not so? So the public's view of a person should not be equivalent to the court's view of that person, and should not be equivalent to the view that is supported by facts and law. So the speculation that I refuse to speculate, I refuse to speculate, is that the court has made its finding. And let's see what the AG would say in respect of that.
Any final brief comments on this matter before we go?
See, on the issue of the criminality, which is in respect of UT Bank and the claims and all that, on the face of it, you know, the Supreme Court comes to a conclusion that, look, you cannot be owners of a property that was used subsequent to your ownership as a collateral. But I'm sure the three of you as lawyers might have come across this. And in my dealings with auctions, there's something seriously going on in the financial sector in this country. And if you've dealt with auctions a lot, this issue of one property being used either at the same financial institution or with different financial institutions and others is very prevalent. Whether those in charge of due diligence in those banks do not do their jobs, or they do not have the capacity to do their jobs, or collude with people who want money from the financial institutions is another matter.
Okay.
But I've come across that several times.
So you're talking about a wrong that is widespread. Does it sound to you, Honorable Yusuf Cedi, like the bail contractors, how they go about their work? They are bail contractors sitting around the courts, and they have one document that they are capable of using to secure bail for as many as 100 people and collect money.
Yes.
And nobody is detecting them. Does that sound
so the
like
term
that?
bail contractors was coined by lawyers
All right.
who sometimes faced with the difficulty of securing people to bail their clients, work under the tree. During those times, it was under the Cocoa Affairs, and see whether you can get somebody to come and bail. Yeah, but it's right. You are right, and that we've been trying to deal with that. Even on matters of taking loans from banks, from financial institutions, Parliament has been trying to deal with that and ensure that there's some level of disclosure on the liability of an applicant for a facility at a bank to other banks, so that we don't overexpose.
But these days, when you register it under the collaterals registry, how are you able to give it again and go register it again to secure, your interest as the one who is giving out the loan?
Because there are many processes that are not complete, and the integrity of those processes cannot be vouched for. I mean, if you are able to digitize all your plans, your title deeds, it should be possible for somebody sitting in the bank to click the portal of the Lands Commission to know whether, in the first place, this property is rightly yours.
Okay.
Whether it's on the books.
All right.
And also to look at the banks, financial institutions, to see whether this property, if it is yours, has been used to secure a facility, and then you can.
Right.
So it actually depends on the integrity of the system.
So the digitization that Dr. Bamia is pursuing deserves all the support to make this work.
Well, he's not pursuing that.
Okay.
The digitization started long before Bamia became vice president.
The lands registry.
Yes, it started long before.
He didn't say he started. He said pursuing.
So why didn't he say that the digitization that is going on, but saying Bamia? Because I was at the ministry. I was at the Ministry of Lands. I was at the Ministry of Lands and Natural Resources. I don't want you to think that it's Bawumia who's initiated.
Okay, that's fine.
It's
that's
not
fine.
Definitely it's not Bawumia.
Thank you.
Definitely.
The criminal prosecution aspect. 1 minute. The criminal prosecution aspect. You believe that the Attorney General should be looking at this, because without that there would not be conclusion to this matter.
Well, Dr. Tupari, a chief PO, has said it all. It depends on what government is looking at. Is government looking at the retrieval of the resources?
Should they be looking at both?
Or the culpability of persons behind the payment?
Should they be looking at both?
Well, it's for government to decide. Is it me?
Thank you.
No, but let me state that when I shook my head, Mr. Kokubako, my brother, noticed it. And somehow he coincided with some submissions he was making. It had absolutely nothing to do with him. I was reading the narration, and at a point I felt that there was something fundamentally wrong with the narration. And then I shook my head. But that coincided with the submission that he was.
Okay, thank you very much. Thank you very much. Yeah. So we can take a break here, Kweku?
Yeah.
All right, we take a break. When we return, we will return to the Supreme Court once again. It has made what people believe is a very significant intervention in national affairs to avoid the unnecessary, very destructive partisanship. New president, everybody go home. Now it won't be the same anymore. Really? We'll be right back.